Bienenfeld Law with Saul Bienenfeld.
A controlled call is a law enforcement investigative technique where a cooperating witness, often a victim or informant, makes a monitored and recorded call to a suspect under police direction to gather incriminating statements or evidence. So here's how it works. So first of all, what's the purpose? The purpose is to obtain an admission or corroborating statement or any other evidence directly from the suspect in their own words. This is usually used in sex crimes, drug, extortion, and fraud investigations where the suspect has previously communicated with this particular witness. How's it done? Well, first of all, there's a lot of preparation. The police meet with the cooperating witness or the victim. They script out or outline key topics to be discussed, and they definitely rehearse how to keep the suspect talking without tipping them off. Then they set up their recording equipment, sometimes using the witness's own phone and sometimes using a police-controlled phone number. But it's easier when it's your own phone because the caller ID would be that person, and the person would naturally pick up the phone. How does the call work? So the witness dials the suspect while law enforcement is listening in real time. Now, the officer may give the witness cues or prompts during the conversation, may write certain things down to tell the witness what to say. And the witness is always encouraged to avoid revealing that police are actually involved in this case, because you never want to tip the other person off. After the call, the recording is preserved as evidence. The conversation is transcribed. It's all written down what everything was said. And it could be used to obtain a search warrant. It could be used to obtain an indictment, and it certainly is going to be used as trial evidence. So in the United States, one-party consent states generally allow this without a warrant if the witness consents to the recording. What a one-party state means is that, for example, New York is a one-party state. In New York, I could call somebody else up and record the phone call as long as that other person is in New York also or in another one-party state, and it could be used as evidence without a problem. But in a two-party consent state, now here the police usually need a court order to make this phone call. In federal investigations, one-party consent is always enough. That's 18 U.S.C. 2511 sub 2C, if you ever want to look it up. But basically that says in a federal case, a one-party consent is always allowed. Now, let's take the example of a sex crime case. Usually it's a minor or a victim reporting inappropriate contact with an adult. So the police arrange a controlled call where the minor, under close supervision, asks the suspect why they did certain things. And if the suspect apologizes or acknowledges the conduct in any way, that's very powerful evidence. So sometimes people just want to say, I'm sorry, to get off the call. That's going to be evidence used against that person, even if the person didn't do it. So a minor might be calling somebody and saying, why did you touch me when I was in the bathtub? And the person didn't do it, but he's going to just say, I'm sorry, because he just feels bad for the minor that she or he was touched and just says, I'm sorry. That I'm sorry sometimes is enough of an admission of guilt to indict somebody. Certainly is enough of admission of guilt to get them arrested. I hope this has been helpful. I hope that you understand it. And if you have any more questions, you could always feel free to reach out to me.